Hvala puno na divnoj saradnji i na ovoj i kao i na svim ostalim TGI konferencijama, kao i uvek zadovoljstvo je sarađivati sa vama. Takođe i da zamolim, da pozdravim ostale naše medijske sponzore, e-kapiju, časopis Industrija, Serbia Energy Mining, CE. Hvala, uvek je zadovoljstvo sarađivati sa vama. Sjajno, imamo još možda 3-4 dole na stolicama, molim vas ustanite svi, pređite za stolove napred. Dok ste vi ručali, mi smo sve čaše i flaše promenili baš zato da možete da se osvežite vodom. Please, ladies and gentlemen, on the chairs, please come on the table. Odlično. Sad panel može da počne. Dajem reč našem sledećem moderatoru, Nenadu Stankoviću, divnom našem advokatu s kojim imamo predivnu saradnju na ovim našim svim TGI konferencijama. Dajem reč i panel može da počne. Hvala puno.
Hvala, Jagoda. Drago mi je što ste ipak ostali na konferenciji posle ručka. Današnja tema i moj panel su nešto što je zaista pravno zanimljivo i pokušat ćemo danas da vam predstavimo kako to zaista izgleda. Znači, do sad smo čuli da negde postoje rezerve, da je moguće raditi istraživanje na duži rok eksploataciju, ali postoje se pitanje kako naći novac i kako da to zaista počne da radi. Danas su sa mnom Janko Nikolić, dr. Milan Parivodić i Bojan Čepić, znači 3 advokata i 1 stručnjak za poreze, a tema je balans između projektnog finansiranja i pravnog okvira za rad. Janko, u stvari, mi nismo prvi put na panelu, mi smo skoro svake godine na panelu i svake godine ova priča dobija neku drugu dimenziju. Pa bi Janko, šta se to promenilo od prošle godine da dođemo do ove teme?
May I switch to English? If that's fine. The question is, what has changed since the last year in terms of regulatory framework or overall industry? I think we have seen more investments. We have seen the overall recognition that the legal framework is good. This morning we've seen indicators that Serbia is almost topping the list in terms of accommodative legal framework, which obviously, you know, being lawyers will find room for improvement everywhere. But I think it's fair to acknowledge that we have a solid framework. The Mining Act from 2015 is a long way from the Mining Act of 1995, which, for those of you who do not know, for the first time recognized the right of private entities to hold mining rights. We've had one more Mining Act in the interim, 2011, and in 2015 the current framework came into place. And in general, when we talk about legal framework, we need to mention this particular piece of legislation, but also Law on Investments, 2015. Some of my colleagues here have played a role in drafting that piece of legislation. PPP Act, which since 2011 enables private actors to partner up with the state. And we have a number of regulations which are conducive to mining investments. When we look forward, firstly, obviously acknowledging positive things that we have at the moment. Going forward, we can take some good advice from more developed, or if we can say, older jurisdictions which have seen more mining investments, such as Canada, such as Australia. We can take some lessons from them as well. Namely, what we have in those countries is the combination of different legal tools, different complementary legislation, and importantly, we also have investments agreements which complement legal framework in a way where a private actor, a private mining company enters into a long-term agreement with the partner state. Some of these things can be more entrenched in Serbia. We can well utilize the existing legal framework to build onto it, to have more investment agreements and to generally ease up on certain things such as taxation, which one of my colleagues will talk about. But those are just the preliminary remarks.
Thank you very much. And now we can talk a little bit about bankability and whether some project can be bankable and eligible for financing. And one of the issues, at least I'm meeting in practice, is issues of servitudes and issues of possibility to pledge or to make a mortgage over as much property as possible. Milane, you participated in almost every reform of the civil law and other areas of law from 2000 until here. Could you tell us something more about this?
Well, you posed the question actually about servitudes and mortgages, and that's a very specific question. And I would have, in talking about mortgaging, you're talking about mortgaging mining rights. Is that your question? Well, I didn't plan actually to talk about it, but that's a very interesting question. And that comes back to a legal question. When does a deposit become a separate thing, zasebna stvar, in a civil law sense of the word? Kad postaje zasebna stvar? And I would say that a deposit, once confirmed by the state, basically by the state certificate of resources and reserves, that is the moment when there is a state confirmation that it has become a separate thing. Probably if you know, actually we are always talking, when we talk about the nature of the permit issued by the state to an investor, we're talking of an administrative permit. But an administrative permit is only one angle of the entitlements which it carries, in the sense that actually I would say that a mining right, looking from a civil law standpoint, is something similar to usus fructus, the right to use and exploit, in the sense that with the moment of separation of the ore from earth, it becomes the ownership of the mining company. And in that sense, it is similar to usus fructus, but that's a completely different thing. We could, as lawyers, you know, talk for hours about it. But what I wanted to say a little bit about is we have a very interesting title of this session, and it is funding. It's about funding a project and the law. Funding the project and the law. And when you look at that, it's quite an elusive question, funding and the law. But when you look at it systematically, and from several years of my experience in this field, each one of us has to look at a project systematically, understanding the entire ecosystem of a private project. And when we look at it from an aspect of an entire ecosystem, which is needed to function properly and in concert to make a project happen, then things become conducive to realizing a project. And when I talk about the ecosystem, I think it is critically important that who are the actors in the ecosystem? It is naturally, it's an investor who has first explored and maybe one day discovered something. Then there is the state, which has its political aspect, which has its civil service aspect, and there are laws which need to be applied. Before, the situation was quite simple in the sense that the state controlled the companies, mining companies, it controlled the state itself naturally. The laws were written for those public companies, and it was all quite simple. And with a nod of the head of the political party, it could have been done, provided a discovery was made. Now, in a market system, it gets much more complicated in the sense that you have investors, you have the state and its laws, then you have the banks. You need to raise money. And for those banks to raise money, they need clean legal opinions from lawyers. And then you have the self-regulation of the industry, which is in a very nascent shape in Serbia. In the world, you have self-regulation as a very important aspect. Then you have the stock exchange. And looking at all that, investors, the state, stock exchange, self-regulation of the industry, lawyers, then there is the competent person, a critical aspect, and there are the banks. It is very important. You have the service providers, service providers or facilitators, which is banks, they give money. The stock exchange also is used for raising money. The competent persons are those whose opinion is respected and believed by the financial institutions and by the stock exchange. Then there are the lawyers, who also have to provide a positive legal opinion. Then there is self-regulation by the industry, which is typically by standards above the regulation of the states. And then there is the state, naturally, with its laws. The point that I want to make is that all of these actors of the ecosystem, all of them must have one paramount idea when discussing and thinking about their role in the project. And that is that all of them are on the same job of making the project happen. They're all on the same job of making the project happen, including the investor, including the state, and all the other facilitating actors. In that sense, the role of the state, in the previous times, there has been a very strong engineering aspect of the mining law. Very strong engineering aspect of the mining law. And lawyers actually had a lower hand to a certain extent. It was more the role of the state was to prove the discovery. It was not the competent person. The role of the state was to confirm feasibility of the project, which again, in a modern system is not the case. The role of the state, of course, still is the allocation of the exploitation field, the giving of the exploitation permit. But the role of the state was not, in the previous times, legal security. Legal security, giving legal security to investors was not an issue in communist mining laws. So, yes, so that makes a huge difference in the sense that the new role of the state is exactly to give legal security. And that legal aspect of a mining law is increasing in importance, whereas the engineering aspects should not so much deal with the questions of proof of discovery or feasibility, because this is done by independent professionals like the competent persons, and then verified by the stock exchange, by the banks, and so forth. So the state, basically, in my opinion, should pay particular attention in the future to giving legal security, and that also includes investment agreements and a very clear security of tenure, giving such legal security that it secures further investment, that the state becomes actually an agent of development. Then, naturally, the key duty of the state is safety of the workers and the safety of the environment and the people around, to secure accurate reports on what has been discovered, and supervision of all those activities, and in case, take away the permit if the investor is not behaving properly. So with this, I will stop and we can then continue.
Okay, thank you very much, Bojana. Well, Bojana, this area is somehow murky for me, and I'm not really expert for the tax issues. And when we're advising someone to enter into the investment or to raise the project funding, yes, we are discussing the legal issues. We are discussing whether the all permits and licenses are in place. And yes, we're discussing bilateral investment treaties and how the investor should be secured. And I agree that in communist era, it was no any security for the investors because there's no investors. But from the tax standpoint of view, how it looks like?
Yeah, thanks. From the tax point of view, what we are witnessing in the recent period is the change in the tax legislation in Serbia, mostly to become in line with the EU regulations. That applies both to, especially to VAT, but also goes along with the corporate income tax and other forms of taxation. What we see in practice is that when the foreign investors are planning their investment in Serbia, for example, in mining sector or also in other sectors, is basically they're looking for some kind of certainty, whether they are in anyhow certain about their tax position in Serbia. Once they make the investment, what's going to happen with their tax liabilities, what's going to be the approach of the tax authorities, are they going to be safe if anything goes wrong and they go to the court, and so on. What in Serbia there is, I would say also in the countries in the region, there are some changes that happened recently. There are also some changes that are announced to happen hopefully soon. For example, when it comes to VAT, what's happened recently is that we aligned the rules as much as possible with the EU rules, especially when it comes to the place of supply of services, taxation, and so on. And also what's important for foreign investors is, for example, in the construction industry, if you have like some kind of subcontractors who are constructing providing any kind of construction services, their services are usually not subject to VAT. Instead of charging VAT from the subcontractor to the main contractor, to the investor, it is the investor who just applies so-called reverse charge VAT mechanism. What's important with this is that this VAT is cash neutral and is cost neutral. So
you can mention an umbrella clause from a different BIT on the basis of the most favored nation clause, and ask to, I frankly don't believe that ICSID arbitration would accept the most favored nation clause in terms of the assent for the ICSID arbitration. That's my feeling.
But just my question is, it means that in Serbia now, there are no you don't have studies on how to use the legislation, the internal legislation, before you go into an arbitration to protect.
No, we don't have to.
All
We
right.
don't have to exhaust all local remedies before going to ICSID.
Okay.
If there is a BIT, if the BIT agrees for an ICSID, you just go for example, 3 or 6 months notice of a problem to be resolved. If it's not resolved, you can file before ICSID without exhausting the local remedies. Okay?
And not only this, once you before the exit for the arbitration, and if you're applying for umbrella clause, then you need to think about a few things. First is that this umbrella clause is variously defined in the various bilateral investment treaties. And second, that even the exit has a very different practice in the different awards with this respect. So even the small difference in his wording is leading to the different decision. And what is the main problem in investment arbitration today is that this is not something which is very reliable in terms of practice. So you have 3 arbiters which can interpret each particular situation differently.
But you know, I am one of the members in the board for the moot court in investment arbitration. We just had now the rounds in Stockholm. And this was one of the issues that we had in our hearings. And this was why I was asking whether in Serbia you've been doing any kind of studies, legal studies towards this concern. But I understood you were telling me about the international system, and this is how it operates, with the umbrella clause, with the investment agreements and everything else. But I was just wondering if in Serbia specifically, there is any kind of study related to the application of the domestic legislation in this sense. And thank you very much for clarifying. It was a pleasure.
You're welcome. Milan, yes, please.
There is one very important thing to know about, Janko very well pointed the key aspects, very well pointed the key aspects of legal certainty for a major investment. And when you look at that list of the IBA, actually a number of those questions have, to a satisfactory degree, been present in Serbia. For example, the termination. Our law on mining is very clear that termination can only be based on a good cause. That's completely clear. Second, talking about fiscal stability, we have one very good perk, and that is we have a 10 years tax holiday if you invest more than, I don't know, $10 million and deploy more than 100 people, you have a tax holiday of 10 years on the tax, on the corporate profit tax, which is a wonderful incentive. And which gives a lot of protection in terms of fiscal stability already. There is one thing which we should understand in terms of also talking about ICSID. There is the notion of acquired rights. You have a right which you have acquired. You have bought land, and that is an acquired right, and no one can take it away from you. But on the other hand, the law on mining in 2015 gave certain promises. It gives certain promises which says, who has the certificate of reserves obtains, the word dobija, obtains a mine exploitation field permit. Obtains an exploitation field permit. Which means that all of you who are doing exploration in this country have based your decision to explore in Serbia on a statutory promise that if you hit a discovery, and the state confirms your discovery with a certificate of reserves, that you will definitely get an exploitation permit. The state cannot revoke that easily. It is a statutory permit which could be basis for arbitration against the state. So even now, if the state changed the law, it would actually not break acquired rights, but it would break statutory promises on which investors have relied, which is some kind of a semi-acquired right. Yeah, so that's...
Well, this is basically a good point, and well, we didn't have, to the best of my knowledge, any arbitration with respect to the mining rights, but we have similar situation with the changes of privatization law, and the international arbitration ultimately decided that any change of the privatization law was not possible to be implemented retroactive. So this is something which state needs to take into consideration when they are changing the mining law, if they are planning to do so. Bueno, we started talking too much legal, and tax is also part of it. Do you have something to add?
Yeah, let's get a little bit back to taxes. Yeah, maybe just would like to add a couple of points about maybe a couple of crucial aspects of tax aspects of investments that we are seeing in practice when the foreign investors are coming to Serbia, either for exploration purposes or for other sort of investments. So maybe 3 or 4 points. The first thing that are usually asked are about what will be the tax kind of presence of foreign company wanting to pursue some investment in Serbia. At the moment, we have for foreign companies wanted to perform business activities, including exploration, any kind of investments in Serbia, our tax legislation, like corporate tax, VAT, customs legislation, also not to forget to mention foreign exchange legislation, which is still a little bit old-fashioned in Serbia, and and sometimes it puts a lot of obstacles in making cross-border transactions. For example, you have the list of the payment transaction codes prescribed by the National Bank of Serbia, and when you want to make the transfer of funds from Serbia to abroad or from abroad to Serbia, you have to identify that kind of transaction in that list of codes. If you cannot find it on that list, you cannot make the transaction. Basically, you can try to make it, but the commercial bank that you are having the bank account with will prevent it from completing. Second point is about the presence in Serbia. For example, from tax point of view, foreign companies can set up a presence in Serbia either as a limited liability company or as a branch office. There is also some other alternatives like representative office, but it cannot be usually applied in practice for this kind of activities. Also, foreign investors are looking for the tax treatment and the way how to import the equipment, the materials, how to bring the people from abroad to Serbia. There is a lot of regulatory matters there, some of them being sometimes very hard to, or some requirements, some of them being sometimes very hard to complete and meet. All foreign persons coming to Serbia can become, for example, liable to personal taxation when they come to Serbia. There's a lot of permits and regulatory matters to complete in that respect. When it comes to import of equipment, there is a lot of customs implications on that, VAT implications on that, depending on what kind of equipment is imported, from which country is it imported, and so on. Serbia has a couple of international agreements, for example, with the EU, with Russia, with Turkey, with the local countries here in the region, allowing import of equipment and materials without any customs duty. And this is very often used, so that being one of the points important for investment. And the last point that I would like to make is about the exit strategy from the investment, which brings back to me to the application of bilateral double tax treaties. When the foreign investor has a subsidiary in Serbia performing some activities and wanting to transfer the shares in this subsidiary to another company, that kind of transaction sometimes can be, sometimes is exempt from the capital gain taxation in Serbia, which depends on from which country is the investment made and to who is the owner of the Serbian company. So that brings us back, one step back to the tax planning of the investments, meaning that it's not, it's important from which country you are making the investment and from which country you are providing the funds for financing the investments. So a couple of points there.
Thank you, Ban. Well, do we have, yes, please. Could you bring a mic there? Thank you.
Ja sam Slavka Zajković iz Instituta za arhitekturu i urbanizam Srbije. Htela sam da postavim jedno pitanje. Odnosi se na domen uloge države u pružanju pravne sigurnosti, ako sam dobro razumela tu ključnu regulativnu ulogu države. Kako u današnjoj situaciji ogromnih rizika i ogromnih neizvesnosti globalno na planeti bilo koja država može da preuzme tako čvrstu, da kažem, funkciju pružanja čvrste pravne sigurnosti i to posebno kada su u pitanju finansiranje projekata koje je veoma često u formi joint venture investicija. Znači one su same po sebi jako riskantne, rizične u mnogim domenima od strateških do operativnih i sad je pitanje kako uopšte bilo ko može da bude na neki način garant i da obezbeđuje pravnu sigurnost. Ako govorimo o pravnoj sigurnosti koja se odnosi za kompanije, za strane investitore, bez obzira za investitore, šta je sa pravnom sigurnošću lokalnih zajednica, odnosno jedinica lokalne samouprave, gradova i građana? Kako proces participacije javnosti lokalne samouprave može da utiče na ovu potencijalnu ulogu države da pruži čvrstu pravnu sigurnost, s obzirom da je neophodno provesti proces demokratizacije kroz uključenje građana. A znamo da su brojni problemi u odnosu na, da kažem, komunikaciju sa lokalnom zajednicom, na realne probleme i ekološke, i socijalne, i ekonomske, i u svim sferama. I još jedno, ako mogu, pitanje, to je da nešto, ako možete nešto više da nam kažete o instrumentu korišćenja prava službenosti, obzirom da je to takođe globalno popularan instrument koji koriste naravno i velike kompanije, veliki projekti, naročito u odnosu na procene uticaja tog instrumenta, recimo na lokal, u kojoj meri je to opravdano, u kojoj meri nije. I ako može još i treće pitanje, to je već veliki broj, ja se izvinjavam, mi znamo da rudarske kompanije koje su dobile istražna prava ovde i eksploataciona prava, nakon pribavljanja tih saglasnosti, tih odobrenja i dozvola građevinskih naročito, sistematski povećavaju svoju vrednost 5 puta, 10 puta na globalnom tržištu u nekom od berzi svetskih. I sad je moje pitanje, kako jednoj tako moćnoj, recimo, instituciji kao što je investitor, jedna mala država može da da bilo kakvu garanciju i pravnu sigurnost, s obzirom da ona već ulaskom i dobijanjem odgovarajućih dozvola i odobrenja već stiče, da kažem, jednu veliku supremaciju finansijsku samim tim. I još to pogotovo u uslovima, čini mi se, vrlo neregulisanog finansijskog tržišta kod nas. Kod nas su apsolutno nepoznati novi finansijski instrumenti koji su jednostavno u domenu finansijske i fiskalne politike u svetu. Ja se izvinjavam na predugom ovom
Hvala vam.
diskusiji.
Pitanja su definitivno interesantna. Pre nego što kolege odgovore, meni samo drugo i treće pitanje su mi, bar meni, potpuno jasno. Prvo pitanje mi nije do kraja jasno. Da li vi kada pričate o pravnoj sigurnosti, pitate pravna sigurnost u ugovornom odnosu između države i privatnog investitora, ili mislite na sigurnost koju država treba da obezbedi u nekakvom pravnom sistemu da bi investitor mogao da ulaže? Šta od ta dva?
Pružiti. Kako uopšte obezbediti platformu za pravnu sigurnost u odnosu na oba aspekta? Evo, ili odgovorite na neki od njih.
Milane, mislim da je pravo pitanje za tebe.
Ako mogu samo organizatori da daju sendviče publici, pošto ću ja govoriti 3 sata. Gospođo, vi ste postavili izvanredno pitanje i vrlo iskreno. Suština je da države kao trgovci se bore za investicije. Znači, države jedna drugoj konkurišu. Najvažniji parametar konkurencije za dobijanje investicija je pravna sigurnost. To je ono što investitori najviše vrednuju. Mnogo više od subvencija, čak i poreskih olakšica. Znači, najveća vrednost koju država može da da u međunarodnoj konkurenciji da dobije investiciju je pravna sigurnost. Kada je država Bogom obdarena da ima i mineralne resurse kao što Srbija jeste, onda je velika grehota ne spojiti taj Božji dar i organizaciju pametnu među ljudima, obezbediti pravnu sigurnost i to mineralno bogatstvo koje postoji i ne pretvoriti to u novostvorenu vrednost. Nema kompanije koja je jača od države. I najmanja država može veliku štetu da nanese velikoj kompaniji. Jer ona prosto ima suverenitet na svojoj teritoriji. Borba s državom nije ravnopravna čak i kada je velika kompanija na jednoj strani i manja država na drugoj strani. To što kompaniji skoči šestostruko vrednost ili desetostruko zbog nekoga projekta, njoj isto tako može da isto toliko puta padne vrednost ukoliko bude uhapšen direktor lokalno ili ukoliko bude oduzeta dozvola za rudarenje ili ukoliko se desi neki poduži štrajk radnika ili se pobune ljudi i krene neko puškaranje oko rudnika. I to se dešava. Dakle, ono što sam ja hteo da kažem jeste da funkcija države jeste da omogući blagostanje svojim građanima. To je njena osnovna funkcija. Njena funkcija nije ona sama. Njena funkcija je da pomogne, olakša život svojim građanima. Ona će to uraditi najefikasnije ako pruži pravnu sigurnost svim investitorima, pre svega domaćim pa i stranim. Nikada nije previše pravne sigurnosti. To je kao da kažete previše higijene. Ona može biti, one države koje su najuspešnije u privredi, Nemačka, Japan, Koreja, Singapur, Britanija, Amerika, to su najjače pravne države. U razvoju civilizacije, one države koje su imale najrazvijenije pravne sisteme i najefikasnije štitile trgovce i proizvođače, to su bila najrazvijenija društva od rimskog prava do današnjeg dana. Ja potpuno razumem vašu brigu za lokalno stanovništvo i za lokalnu samoupravu. U Srbiji taj problem nemate, jer kod nas nema lokalne demokratije uopšte. Kod nas partija koja je na vlasti kontroliše celu vertikalu vlasti. U zemljama koje su...
Nobody pays VAT, it's just reporting input and output VAT, which is very, I would say, stimulating for this kind of industries. From the corporate tax perspective, we talk about financing the projects. When we talk about tax aspect of financing the projects, from the corporate tax perspective, basically the Serbian legislation allows a 5-year carry forward of tax losses. So when you start investment, you make some, if it happens that any losses are incurred, they can be carried forward to offset future taxable profits in the 5 years. The 5 years carry forward of the capital losses on capital transactions, and also one of the new announcements in the change of the corporate tax legislation, if it happens to be adopted by the parliament, by the Serbian parliament by the end of the year, is going to be the tax incentive for the research and development activities, meaning that if you have any kind of qualified, we still don't know what in practice is going to mean qualified or by definition research and development, that kind of expense will be recognized in the double amount for the tax deduction. That means you can decrease your corporate tax base for 200% of your research and development expenses. If you incur 1 million of these expenses, you can decrease corporate tax base for 2 million, which is quite good incentive. As I said, hopefully if it becomes adopted by the Serbian parliament, it is at the moment proposed by the Serbian government. So for now.
Thank you. Samo jedna molba za sve prisutne. Ako možete, slobodno se uključite, pitajte što god vas zanima, stavljajte svoje primedbe. Izvolite. Could you just wait a second for a mic? It's coming.
Now it is. I'm Professor Fernandes Yankov. I work in Brazil, Portugal, and I'm happy to work here in Serbia. I've been working in the field of mining law in Sao Paulo, and it was quite exciting, I must admit. But I would like to ask a question to the colleague Pari Vodic, if I'm pronouncing that correctly. I understand there was a concern regarding the mining right becoming a financial instrument. And I found it quite interesting the way you approach in terms of legal theory in mentioning the idea of usus fructus. But I would like to ask here in Serbia how the financial market is working in these terms, because our experience has showed us that the mining law was not enough. We had to change the financial market, the legislation that would allow us to issue an instrument. So the mining right would become a bill. And this bill would be subject to become a financial instrument. And then we could have a deposit account. So I would like if you could clarify a little bit how in Serbia this issue is being faced in terms of the financial market. Thank you.
Thank you, madam. Your question is a very advanced one. for the state of Serbian mining law. It's very interesting. We still do not have, for example, securities backed by mortgages. We still don't have that. We don't have securitizations still in Serbia. The concept of a mining right as a civil right, a civil law right, belonging not to administrative law but to private law, is very unclear. It's very unclear. When I mentioned the relationship between the state as the owner and the mining company as an usus fructarius, I actually made an analogy with old French law. In France, one kind of usus fructus is mining. So definitely there are certain entitlements within the administrative permit which are of civil law nature to take away the substance, which is actually usus fructus is without using the substance. That's the difference. And here you're exploiting the substance. I agree. I agree. Only looking at it from a very long perspective.
Absolutely.
I agree. I agree with you. Usus fructus is salva rerum substantia.
Yeah, we cannot
I
use
know.
that for the financial market in terms of explaining the financial instrument that is based on this mining right. So this is why I'm asking specifically this question. How, in terms of legal theory, you think this could be supported in Serbia? Because without this, it is almost impossible to think about finance. Because what are the guarantees?
Well, I understand currently the administrative right granted by the state is transferable under the law, but that is very seldom used. Typically, the structure is based on the fact that the Serbian subsidiary owns the right, and then the parent company or the parent of the parent actually does the transaction somewhere on the British Virgin Islands and some typically exotic summer holiday place. So we didn't have, to my knowledge, transactions which directly implied changing of hands of the mining right.
But how do you see, is there any kind of limitation towards foreigners? Because, for example, some countries, they had this option. You can do it within nationals, but you cannot do it to foreign companies. And this was
We
a big
don't have
problem.
that limitation.
Okay.
Foreign companies can do that. You had it, for example, in Kazakhstan, that irrespective of where the transaction is happening, if it reflects the use of Kazakh natural resources, it's prohibited by Kazakhstan law. This is not the case in Serbia. The Serbian law covers only the territory of Serbia, so transactions which are beyond Serbia are not controlled by Serbian law.
This was not my concern. Sorry if I'm taking too much time in this debate. I'm sorry if there's anyone that would like to ask, I would stop. But what
very
we
interesting.
saw is that we can do the transfer within nationals. But if there is a foreign company operating in the country, this company cannot have the transfer of rights. Therefore, this company could not issue the instrument. So this is what I'm asking you. But if you're telling me that in Serbia you don't have the transfer, so then
No, we do have the transfer, but we don't have the instruments. What kind of instruments?
How do you transfer them? Because you are transferring the concession,
You transfer it by a contract, basically,
Right.
with the permission of the state.
Right, but you don't have the instruments being issued still because you don't have the financial legislation that would
Absolutely,
accept it as
no,
a
we
security.
don't.
I
Yeah,
understand. So there's room for us to think about it and to work on
Why
it.
not? Why not?
Thank you very
Could
much.
be fun.
Thank you. It was interesting, but it leads us to another question for Janko. Janko, you're a practicing lawyer, as all of us are. What is the best practices you have with respect to the project finance? When you need to respond to the client, what is the options and what is the best practices? What is your first response?
I think we need to go back to the needs of mining companies. So some companies are large companies that do not need to generate funding externally, or needed to generate it in a quite limited way. But one commonality of companies that do need quite a lot of funding and companies that do not is the fact that they require long-term security, long-term stability in order for potentially financiers to join in or to fund it entirely. And in that sense, International Bar Association in 2011, the top worldwide association of lawyers, has identified a number of best practices which I think can be transplanted across to Serbia, thinking about legal framework overall. Obviously, land rights, land acquisition, security of land rights long term. Whether an exploration and exploitation license long term will be stable administratively, from point of administrative law, from any other point of law if we have investment agreements. So whether long-term stability of land rights is there. Secondly, duration. So we have possibility to extend exploration, exploitation licenses, but once we have discovery, once we have commitment of a company to invest and to fund it itself or seek external funding, we need to think about duration. So 25 to 30 years plus extension right is the industry standard in some developed jurisdictions. Infrastructure, well, quite practical and quite important. If we have remote areas that have significant reserves, let's say, lithium, copper, gold, we need to think about building access infrastructure. And we have numerous examples worldwide how that's approached. One possibility is to have the possibility of an investor funding access infrastructure with the right to set it off against future royalties or taxes that such companies to pay. So that's one possibility. Thinking about initial large investments that a company is committing, and the way to offset it is one of the best practices that we've seen worldwide. Taxation, I won't dwell into it too much, but it's important to say that in investment agreements, comprehensive investment agreements that we've seen worldwide, all taxes and tax-like payments are listed. So we comprehensively list all current and future levies, taxes, charges that will be imposed on investing company, and say, well, at this moment, at the time of signing, we have these obligations in terms of taxation. So being completely clear about what we are including in that contract that's to last long term. An important one are basically what happens if we have an adverse change in law. If the law changes after you've entered into an investment agreement, and the question becomes who needs to pay, who's liable, are there any obligations by the state or by the investor? So including stabilization clauses in those investment agreements is conducive to investment. So whoever's funding it, be it the company itself, if it's a large mining company, or a junior company or mid-sized company seeking external funding, they want long-term stability in terms of legal protection if we have adverse changes in law. Termination rights, basically the assurance that mining rights will not be unilaterally terminated by the state unless we have force majeure event or we have persistent or material breach by an investing company. So obviously termination for good cause only. And finally, in terms of international best practices that we could implement or heed advice from is basically the desirable dispute resolution either before ICSID or ICCC, so International Chamber of Commerce or international dispute resolution body in Washington for the resolution of international investment disputes. So we can obviously take some advice from these best practices that IBA has developed, and obviously in this current legal framework, tailor it to Serbian legal climate, if I can say that. So
It's not a storm.
it's not a storm. I mean, since 2015, things have stabilized. We've seen numerous companies present in Serbia. We've seen the fact that Serbian mining laws are topping the list of European mining laws. So there's not much to, so to speak, complain. But obviously, there are certain things that can be fine-tuned in that sense. So.
It looks as we have a question again. Could you bring a mic to the lady?
Not working. This is really an interesting topic. You mentioned the International Center for Dispute Settlements regarding the investment agreements. And it is my curiosity, and I think it is very important to know how Serbia, especially in terms of the legal system and the legislation, is thinking about dealing with the most favorable clause in the contracts. Because this has been really a big issue when we have investment treaties and we have disputes under arbitration. The most favorable nation clause has really been an issue. How is this being faced here in Serbia within the community that is preparing the legislation and that should face this kind of challenges?
Well, thank you for the question. The issue of bilateral investment treaties.
The principle of most favorable nation, the favorable nation clause, when you have a treaty between two countries, especially in these investments, whenever you have a kind of policy towards one country or towards one company, this policy should be the same applicable to all of them within the country. And this has been an issue.
It depends how it is defined in the treaty.
No, but the principle is settled. This is a principle within the center. You cannot get out of this. Otherwise, you cannot get into the arbitration. So this is why I'm asking how you envision this, how this is being regulated in Serbia, if it is being regulated in Serbia.
Well, it is in Serbia. How it is regulated in Serbia?
How the principle has been regulated in Serbia.
But you have a law on foreign investments, and you have the bilateral investment treaties with each individual country. So it depends of the country of the origin of the investor. He's protected by his own bid.
Oh, all right then. That's okay. Thank you.
So this is the principle. So if you're asking how it looks in practice, then
look in terms of mining, because we are talking about the mining issues. And when you have a contract with a foreign company, these contracts are all subject, depending on how you're writing, but usually they are subject to arbitration. And the most favorable nation
I can tell you, madam.
is a very important clause.
Absolutely.
So
this clause is a second-tier clause. The first clause is the umbrella clause in the BIT. So if there is an umbrella clause, then the state has actually given prior assent to an ICSID arbitration. So the investor may just file a lawsuit before ICSID arbitration, and that shall be considered an assent in terms of the regulations of the ICSID arbitration. If that state does not have an umbrella clause, if the state of the investor does not have an umbrella clause in a BIT with Serbia, then there is a possibility of relying on the most favored nation clause.
Yes, this is the system.
Absolutely, and the most, so you can demokratizovanije od naše, gde postoji podela između centralne vlasti i lokalne, i gde lokalna vlast vodi zasebnu politiku, to je veliki problem za rudarske kompanije, jer moraju da reše jednačinu i sa nacionalnim nivoom i sa lokalnim nivoom. I često je lokalni nivo veći problem, jer nemaju svest o odgovornosti nacionalnog razvoja i onoga što donosi rudarski projekat. Tako da, tema vam je pitanje je vrlo lepo i da, pitanje službenosti. Službenost je pravo koristiti tuđu stvar u obimu svojih potreba da prođeš kroz tuđe zemljište da bi stigao do svoga, da provezeš automobil ili da luk pređe preko tuđega krova i spusti vodu u tuđe dvorište i tako dalje. To su službenosti. Definitivno u rudarstvu su one vrlo važne. Pogotovo kada imate situacije, na primjer, u Srbiji poljoprivredno zemljište koje je u državnoj svojini nije na prodaju. I to je veliki problem. Država ne sme da raspolaže poljoprivrednim zemljištem koje je u njenoj svojini. Onda to mora da se rešava, na primjer, putem službenosti ili nekih dugoročnih zakupa, kao što je antihreza se to zove u drugim nekim pravima i tako dalje. Eto, ukratko, to bih vam rekao o službenostima.
Hvala, Milane. Da li ima još pitanja? Prvi put, drugi put. I ako nema više pitanja, hvala vam na pažnji, hvala mojim kolegama u panelu i velike mi je čast i zadovoljstvo da najavim sledeći panel i njegovog predsednika Dragana Miloševića. Hvala vam.